Hello, my true crime lovelies. How are you? I hope you are well. I hope you are as lovely in life as you are in my mind. And if not, I hope you're getting there. I hope tomorrow is a better day. At least it's a new day, right? Okay, so Judge Everett, or Daddy Milk Dud, as Kathy likes to call him. I'm taking license, but something to that effect, has ruled on Donna's motion for a new trial as well as her motion for acquittal. You and I didn't go over the motion for acquittal, but we did go over in great detail her motion for a new trial, and pretty much it went how we thought it was going to go. I've watched a couple of videos of other content creators commenting on it, and I found it interesting. I want to start with the sidebars because a lot of people skipped over it. And at first, when I got it, it's 57 pages, the whole order. I was kind of freaking out because we took like an hour and a half to go over the 18 pages. But this is my strategy. We're going to go over the sidebars, which had a lot of side eye from Judge Everett. He was like, no, let me set the record straight. Da 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 da. Da-na-na-na-na-na-na-na-na. I'm messing it up, but if you know, you know. And so I want to start with those, and then we'll get into bits of what the motion said, because there's some key pieces, some key points he made that are a little spicy that I want to go through. We don't need to go through it word by word, right? All right, so we're gonna do that, but first I'm gonna run the intro so I can thank all of the members. We're over 700. I appreciate each and every one of you. Memberships start at 99 cents if you're feeling left out, but no pressure to become a member. I appreciate you all, I promise. I will see you on the other side. Sound warning. 33 seconds of loud music. And Sweet Pea says he does not want to be left out of this. So he's saying hello to you all too. Uh-oh, let's see. There we go. Ta-da! Can you guys see that? Okay. And yes, I'm still in the braless brigade. It's going to be that way for the rest of the pregnancy because my skin is on fire. All right, let's get into this, shall we? So, just as a refresher, some of the things in the motion were Donna complained about the jury, loose lips sink ships. She complained about not having enough time to decide if she was going to testify. She complained about Judge Everett's rulings. We're going to go right into not having enough time to testify. Because in my video, I was saying I was surprised. I was wondering if in the next morning she were going to come back and say, I changed my mind, right? Because when she answered his question, if she wanted to testify, she had a caveat. She, just like the Cardigans, she's still in caveat from Nancy Brophy. And that caveat was, not at this time. And we didn't hear anything more about it, right? But there was stuff going on behind the scenes. And this is why I say Judge Everett had his side eye in full effect, because you would have never known these conversations happen based on what was written in Donna's motion. And I guess Judge Everett was like, oh, you showing out for the cameras? No, no. Let me set the record straight and let me bring in receipts. So we're going to go over Judge Everett's receipts. This is the sidebar. So it happened during court. We didn't hear it. It's not recorded. But of course, the court reporter documented it, right? So the court, that's Judge Everett. The parties can briefly approach sidebar conference as follows. The court. In researching, and so this is the day after. In researching some matters last night, in anticipation of moving into closing today. Oh, wait, let me practice my Judge Everett.
I did want to confirm with the defense that the defendant is not asking to testify.
Mr. Zellman, we talked to her for a somewhat lengthy period of time last night over the phone while we were preparing. She informed Miss Fulford and my paralegal, they had taken her off speakerphone at this point, that she felt secure in her decision. So whatever it was, maybe they were there in person, Fulford and the paralegal, and Zellman was somewhere else, and that's why this speakerphone is relevant. Y'all let me know. If Your Honor would like to have Mrs. Adelson come to the bench, I can have her the court.
Just have the bailiff bring her over here to the sidebar.
Mr. Zellman. Yes, sir. The defendant present the court. Mrs. Adelson.
Before we move into instruction on the law and the closing arguments this morning, I once again wanted to confirm with you that you are firm in your decision that you are choosing not to testify.
The defendant. The defendant! Shout out to Sue Opper. Yes, Your Honor, I am. The court.
You are absolutely firm about this decision?
The defendant. Yes, I am. The court.
Is there anything further that you need to speak with your two attorneys about on this matter?
The defendant. I would like a few minutes to talk to them, yes, if I could. The court.
As to this particular decision or some other matter?
The defendant. As to this particular decision. The court.
On this, I will provide a few moments. After this, we do need to resume timely. Yesterday, when the court made reference to contempt, this concern has continued to occur, and also not returning from the conferrals. We need to resume court. If you need to speak to your attorneys now concerning whether you wish to testify, I will allow you to do so. I'm going to give you 10 minutes to accomplish this. When 10 minutes is up, we do need to move on.
Ms. Kappelman. Judge, is it your intent to go right into instructions and closing at the conclusion of the 10 minutes? The court.
That would be my intent.
Ms. Kappelman. I would request 30 minutes because I need more time to get my closing act together. So maybe that can give a little more time for the defense to do what they need to do as well. Both parties need to share their closing PowerPoints and demonstratives with each other too. The court.
We'll make it 30 minutes then. The reason why I am bringing this issue to the party's attention is only because I believe the appellate cases of this state make clear, prior to instructions and closing, a request to reopen the case or for the defendant to testify, the exercise of the fundamental right leans towards allowing this to occur. I am giving her this last opportunity to confer with counsel and make this decision.
So that I think is interesting. Judge went home and did some research and looked at what other cases, appellate cases, this matter was brought up on. And remember in our first video, or in the video with the motion, I said that I was surprised that the state closed because we saw in the Lori Vallow Daybell case, they didn't close. I'm sorry, the defense did not rest until the next morning. So I was surprised that the defense had rested that Wednesday night. Although, as I said previously, I'm sure it would not have been a big to-do to say, if had she changed her mind, like, they don't rest. You know, so I thought that was interesting. Crossing his T's and dotting his I's. Love me some Everett. Miss Fulford, may I say something, Your Honor? After the state is done with their closing, we're going to need a break for time to set up our stuff. The court.
That's fine. Will any recordings be used as part of your closings today?
Miss Fulford. Yes. Miss Dugan. May I ask one more thing? Is it the court's intent to read the stipulation prior to jury instructions? The court.
Yes, because that will be a part of evidence in the case.
Sidebar conference concluded. The court.
Before we bring the jurors in, we will have a brief break to allow the parties to set up any demonstratives and presentations that they will need for closing arguments.
So he's announcing it to the room without saying, I'm giving Donna those 5 minutes or 30 minutes, right? So we didn't know contemporaneously that this was happening. So I'm glad that he is sharing the receipts with us. Thank you, Judge Stephen Everett.
Please inform the jurors that we will bring them out about 9:25. Until then, the parties may do what they need to do to set up to get ready. I will print the copies of the instructions if anyone needs to stretch their legs, use the bathroom, please do so. As to all observers, for the closing arguments today, and this is very important. Once again, you are not to make any gestures. You are not to make any facial movements. You are not to, in any way, indicate to the jurors that you agree or disagree with what is being argued or what is being said. Phones need to be put away and placed on silent or turned off. Does anyone have any questions? Given what was brought up yesterday, that there was either murmuring or some sort of improper influencing or attempt to improperly influence the jury, that is not going to be permitted. You will be removed and also subject to contempt. Please raise your hands now if you have any questions. Otherwise, I expect you to conduct yourselves accordingly. We will resume at 9:25. The parties are to prepare for the closings at this point for all presentations and demonstrations.
Court in recess. So, see, this is how he's bringing the receipts because also in Donna's motion, she mentioned that the court didn't admonish anyone for making sounds or gestures or facial expressions. But again, I contend the number one facial gymnast in the room was Mrs. Adelson. Either way, he's putting it on the record. So when this goes to appeal or when it goes for appellate review, you'll have her motion for a retrial and you'll have his order denying it with the particular receipts, right? So they don't have to go looking somewhere else. Where are those transcripts? It's all succinctly there in his response to their motion, which I love. The court.
We need to wait for the state to arrive, but there is one matter involving the introduction to homicide in that instruction that needs to be addressed. It refers to the lessers. So this will need to be edited before we get started.
Mr. Zellman, yes, sir. Court in recess. The court.
Mr. Evans and Mr. Zellman, if you can approach.
Sidebar conference as follows. The court.
I just noticed this when I was running the copies. But if the lessers are going away, as to the introduction to homicide, I cannot see a basis for which they need to be referred to. As to any references of justifiable or excusable homicide, is there any basis to even discuss this if the jury is not going to be instructed on them as well?
Mr. Zellman, I think we conceded that yesterday, Your Honor. Mr. Evans, we all agreed to the removal. The court.
All right. Let me do this then. As to this first sentence, I'm sorry. The first sentence that describes the accusation. The second sentence goes into what the lessers are. I cannot see a reason to give the sentence at all if there are no lessers. Is either party requesting The second sentence in the introduction.
Mr. Evans, so you were leaving it, how I understand, as excusable. The court,
I think that one needs to go as well, based on the concession, because there will be no instruction on excusable or justifiable use of deadly force.
Mr. Zellman, the second sentence would be out. The court.
Followed by the third sentence. The sentence would remain if you find Daniel Markel was killed by Donna Adelson, you will consider the circumstances surrounding the killing in deciding if the killing was first-degree murder, period. And then the last sentence, I will now instruct you on the circumstances moving into the counts. So all of this gone.
Mr. Zellman, I think that's appropriate given the concession was already made, Mr. Evans, and because I'm assuming nobody is going to be arguing the murder itself was excusable or correct. The court.
I'd say it would be absurd, Mr. Evans, but I understand the question that you are asking for record purposes.
Mr. Zellman, there is no factual or legal basis on which that argument would even be appropriate, given the facts in this case.
Very well. I will change this page. I will reprint page 1, and then everyone will receive copies of the instructions. Were you able to speak with your client concerning, is her decision firm?
Mr. Zellman, that's what she said to us. Yes, Your Honor. The court.
All right. Let's have her place then on the record. And then we'll bring in the jurors after I finish printing these pages.
Mr. Zellman, do you want me to have her?
Yes. Ms. Kappelman, Ms. Dugan, Ms. Fulford, if you can join us at the sidebar.
The defendant present. The court.
Just so all the parties were clear on what was just discussed concerning the jury instructions, with there being no lesser included offenses that will be considered by the jury, the second and third paragraphs of the introduction will be removed, and the second sentence in the third paragraph will be removed. Concerning the other matter that previously came up during the sidebar, Mrs. Adelson, you remain under oath. As to whether you wish to exercise your right to testify in this trial, have you made a decision considering this?
The defendant. I have made a decision. The court.
What is that decision?
The defendant. I am not going to testify. The court.
You are firm on this decision? You are firm on your decision?
The defendant. I am.
Very well. I will make no further inquiry unless the state or the defense seeks for the court to do so at this point.
Ms. Kappelman, no, Your Honor. Mr. Zellman, no, Your Honor.
The court. The colloquy on the subject matter is united through the multiple discussions that occurred the previous day of trial and on this day as well. I will print an updated version of page 1 of the instructions. Everyone will receive a copy from there, and copies will be provided to the jurors so that they can follow along. Are there any other requests or questions?
Mr. Evans, we would request if Ms. Underwood would email us a copy, and that way there are a couple of other people I need to disseminate it to. So if you will do that, that will make it fair. The court.
All right.
Mr. Zellman. And Your Honor, my understanding is the state has a lengthy PowerPoint. Like an opportunity to review that before they do their closing. The court.
All right. While I'm going through and making these changes and getting the copies run, how long do you believe this will take?
Mr. Zellman, how long is it? Ms. Kappelman, everything is in evidence except for a few demonstrative slides, which I can point out to you. Maybe 6 or 7 slides that are not something that's already in evidence. Mr. Zellman, and I need to show you what I have on the drive. The court.
As to those demonstrative slides, if you can point those out, that will probably make this go quicker.
Mr. Zellman, thank you. Sidebar conference concluded. So now we're going to go through with more excerpts. Mr. Zellman. And so our family law expert, we always intended to have her testify. Subsequent to that, we're still trying to make arrangements now that we've gotten clarification on the court's position. So this is going back until, so what we just read was the Thursday morning before they closed. Now, I believe we're going back to Tuesday. I don't know why these aren't dated as to what date it is, but I believe it's Tuesday before Attorney Descalzo testifies. So we always intended to have her testify. So there, I believe they're talking about Linda Bailey. Subsequent to that, we're still trying to make arrangements now that we've gotten clarification on the court's position concerning Ms. Descalzo. We're still trying to make arrangements to get her here. So we have, I think, 6 or 7 witnesses set for today. I don't know how late that will take us. We just were not able to get the other ones here. The court.
So between today and tomorrow, you expect for the defense's case to be presented?
Mr. Zellman, yes, we would ask for the court's indulgence tomorrow afternoon so we can have some additional time to speak with our client concerning her decision to testify prior to her actually testifying. Obviously, you know, it's her right to decide, and we just want to make sure that she understands everything. The court.
I'm not going to press her on the matter, but this has been an issue which essentially has been from the time of indictment.
2023, y'all.
Will you testify at trial?
Mr. Zellman, yes. And I'm not saying that we have not discussed it with her. The court.
Correct.
Mr. Zellman, since almost day one, it's the court.
You will have an opportunity to speak before any colloquy is done concerning whether you will or won't testify.
Mr. Zellman, my understanding with the length of the witnesses, he's kind of tap dancing here, that we anticipate for tomorrow, we would not be calling her tomorrow. If she chooses, it would be Thursday. So yeah, this is Tuesday. The court.
All right. Concerning that, depending on the defendant's decision, well, it depends. How many witnesses will you have to call on Wednesday?
Mr. Zellman, if everything lines up the way that it's supposed to, between 5 and 6, the court.
Okay. I certainly will give you a reasonable amount of time, but if, say, we get to lunchtime or a little bit after lunch on Wednesday, if you need a half hour or so to speak to her, I will certainly give that to you. But to recess for the evening, there's been an opportunity to go over this topic for nearly 2 years. You met with her on Saturday as well concerning trial strategy?
Mr. Zellman, Saturday and Sunday, yes, Your Honor. The court.
All right. I will give some additional time in the courtroom. But depending on where we are falling clockwise, the jurors want to get back to their lives.
Mr. Zellman, yes.
We do need to move this on in a timely fashion.
Mr. Zellman, yes. And there's one final thing I wanted to address, Sidebar. The court.
Go ahead.
The court.
All right, for today, that's the last of your witnesses.
Mr. Zellman, unfortunate. The court.
All right, the person that you need to speak to at the jail, this gives you your opportunity to do so this afternoon. Also, you can speak with your client concerning testifying. Tomorrow, how many witnesses are you anticipating?
So the judge is letting them go home early, right? They finished with the witnesses, so they can, well, not go home, but they're going to go talk to Donna. Mr. Zellman, Maricel Descalzo's flight gets in about 10, I believe. At least that's what my paralegal, Miss Kessler, told us. The other witnesses that we had for tomorrow, Dr. Ruth Rosenberg, Kirsten Adamson. I don't know who Dr. Ruth is, and I don't think she made it, but Kirsten was Wendy's family attorney that had to quit after Dan alleged Fraud, and then Linda Bailey, the one we love to hate. And there's potentially one more in addition to the new one. I'm just drawing a blank, so 5 or 6. The court.
All right. That should put us timing-wise more or less around the same place. Is your client going to be ready to testify tomorrow?
Miss Fulford, it depends on what happens when we speak to this next witness. I suspect that it will be Thursday morning before she will be ready to testify. The court.
Well, not when she would prefer to testify.
Right. When is she going to be ready to stand up here and go through the colloquy?
Miss Fulford, I misspoke. The court.
But if we only have this many witnesses...
Miss Fulford, I misspoke. The court.
Go ahead.
Miss Fulford, because of evidence that came in the trial and some rulings that the court made, it may affect our decision on whether she wants to testify.
So when did this evidence come in? In the last 2 days, girl? What are we talking about?
Mr. Zellman. Specifically, and here they go, 2 people trying to ride one horse, which we know Judge Everett doesn't like, tag teaming. Specifically, there were some additional things that the state added during their case, that although we had access to the materials, we need to go through the exhibits to see exactly what was admitted in terms of emails and other documents, so that we can go over that with Mrs. Adelson. To which I say, if Jackie Fulford could have stayed awake during the trial, maybe she would have made note of the exhibits. Or what was the paralegal doing? Because you already had an exhibit list, so all you had to do is go, okay, this was admitted, here are what the points that were made, which I think you would do during the trial anyway, because wouldn't you want to cross-examine them on those points to kind of take them down a notch? Okay.
Anyway, they want to go over the documents with Mrs. Adelson.
So we are going to need a little bit of time with the clerk to go through that today when the jury leaves the court.
All right. State, do you need to be heard?
Ms. Kappelman, I would like an opportunity to depose the witness over the lunch hour tomorrow if you're going to have a new witness and that person is going to be permitted to testify. I know I'm getting a little ahead of myself, but for planning purposes, I can do it tonight, I can do it before court tomorrow, or I can do it at the lunch hour. But I do want to be given at least the opportunity to do that if that person is going to be permitted to testify. Mr. Zellman, as soon as we speak with her and we make a decision, I will certainly get in touch with Ms. Kappelman and Ms. Dugan and let them know if we are going to use that individual and who they are. So they don't even have the name, or he's feigning that he doesn't remember the name, but Ms. Kappelman is like, look at here. Okay, the court.
All right. I will send the jurors home for the day.
Mr. Zellman, thank you, Your Honor. So that is the end of that excerpt. This, I believe, is Wednesday now. For today's witnesses,
let's go through that before the jurors are brought into the room.
Mr. Zellman. And I apologize, I did not have a chance to prepare a list. At least for this morning, our intent is to call Kirsten Adamson, Linda Bailey, Sarah Newhouse, and Marisol Descalza. I am drawing a blank on Sarah Newhouse. It'll come to me. The court.
For this afternoon.
Mr. Zellman, this afternoon is up in the air, and that's going to require some additional conversations with our client, the court.
During the lunch break, that will be your opportunity to have any final conversations concerning whether she will, in fact, testify. We'll give the jurors a longer lunch break if necessary to accommodate this. Instead of an hour and 15 minutes, it will be an hour and 30 minutes.
So he gives them an extra 15 minutes.
After that, we are going to have to go on the record concerning is she or is she not testifying.
Zellman, yes, sir. The court.
Everyone can be seated. Any discussion that needs to take place concerning whether the defendant will testify does need to occur during the extended lunch break at this point.
The court.
As to the other matter concerning whether Mrs. Adelson will testify as part of the defense case in chief, Mr. Zellman, were you able to speak with her as to a final decision?
Mr. Zellman, I will allow... The shorter answer is we were allowed 20 minutes during the lunch break to speak with Mrs. Adelson. Well, what happened to the hour and 10 minutes outside of that, Mr. Zellman? The court.
In addition to the time you had yesterday and other times.
Mr. Zellman. Yes, Your Honor. Miss Fulford. If I may, Judge, the issue is that we, the court...
Well, one moment. Who's handling this matter? We're not tag teaming any arguments of any sort.
If he said that once, he said it a million times. Mr. Zellman. It reminds me, maybe this is just my own childhood woes, of like if my brother and I were in trouble, the one who grew up in the household with me, we would like tag team the answers. Like, oh, let me jump in and help you. The judge is like, no. Whatever the truth is, let's hear from one person. No tap dancing. Mr. Zellman. Your Honor, what Miss Fulford and I have discussed was the factual issues that are concerning our client's decision. She was more involved in than I was. So the only thing that I intended to address was the time that we had during the lunch break. Aside from that, I'm asking that Miss Fulford be allowed to address the court. So then you shouldn't have said anything, Zellman. The court.
Miss Fulford, go ahead.
Miss Fulford, the issue that we're facing, Judge, is this was 6 days of testimony from witnesses for the state and a great deal of evidence that they have entered. It was a quick 6, too. They were back to back. They were prepared, though. They were extremely prepared. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks needs to be addressed for her testimony, whether she thinks she needs to testify or not, and what her decision is on that. The court.
When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or review the evidence?
Miss Fulford, absolutely. Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not. The court.
The defendant in every single case, Miss Fulford, is faced with this moment as the defense case in chief ends. What are you asking for?
Miss Fulford, I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case. And see, this part, we've actually seen this, but this is where I call BS. Why weren't you going daily through the testimony with her? Or if you're like, oh, I have to prepare for the next day, why weren't you going on the weekends and going through the testimony? Because at this point, the only people who have been testifying this week that they're in have been defense witnesses. So that part I don't understand at all. What y'all been doing? The court.
Miss Fulford, concerning that has been provided by the court. If she wishes to testify, we need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment. There's been time during trial, and specifically, we recessed court early for you to address any issues of witnesses or whether your client would testify.
Tick-tock, tick-tock, tick-tock. You're wasting the jury's time is what I'm getting. Is what I'm picking up from what Judge Everett is putting down. Miss Fulford, yesterday when you allowed us to recess early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that we understood everything that was there because there was some confusion during the trial about things being added and things being removed. Why was there confusion, ma'am? You saw it. Well, you were asleep. But Joshy should have seen it as it was presented to the jury. I don't know where the confusion was. So we wanted to make sure we understood completely what was there. We left here, went straight to the jail, and had the issue with the potential new witness. And I spoke with our client, but that's not ample time to discuss with her what has actually come in the state's case. You had all weekend because the state rested their case in chief on Friday, ma'am. The court.
Your client is in a no different position than any other defendant who has had to decide whether they wish to testify or not. I will give you 5 additional minutes to discuss this matter. From there, the defendant is going to have to make a decision whether she is going to testify or exercise her right to remain silent.
Your Honor, may we approach with our client?
With your client?
Yes, please.
Why can we not address this matter when the jury is out of the room?
Mr. Zellman, Judge, the concern that we have raised a number of times is the response from the audience concerning things that are said by the defense. And although the proceedings are public, that has not stopped the peanut gallery from their comments and laughter. I think this is so unnecessarily derogatory toward the gallery. First of all, he's now calling them the audience instead of the folks in the gallery. And then when he does go back to the gallery, he calls them the peanut gallery. My mom used to call that to the children when we were little and had something to say. And she was like, mind your own business. I don't need comments from the peanut gallery. I don't know. Disdain. It's giving disdain. We are respectfully requesting that the court hear allow Mrs. Adelson to participate at Sidebar as she is entitled, and for the court to us to address additional issues that are weighing on Mrs. Adelson's decision. So there's going to be some foolishness and chicanery. He knows the people who are in attendance are going to laugh at the foolishness and chicanery, the FNC, so he wants it to be a Sidebar. That's what I'm getting. The court.
Please approach. We are not going to do this for very long. The other witnesses for the defense are ready?
Mr. Zellman, yes, Your Honor. The court.
Please approach.
Sidebar conference as follows.
Mrs. Adelson, you remain under oath. Go ahead.
The defendant. So my concern is that I was hoping to have time with my attorneys to go over evidence that I can make an intelligent and informed decision, and 5 minutes is not going to do it. Oh. The court.
Mrs. Adelson, this has not been simply about 5 minutes. From the time that you were indicted
in 2023.
Through going through discovery, through the pre-trial process, through the start of the state's trial, you have had the opportunity to confer with counsel and decide whether you wish to testify. As far as what has come out during the trial, certainly you have been able to listen to this and make your decision. But it is time to make a decision.
The defendant. But I thought I would be able to consult with my attorneys in making the decision, not just, I'm a layman. I'm not making it on my own. The court. Are there any other legal arguments that you have to make concerning this, Mr. Zellman? Your Honor, the concern that I think my client is inartfully phrasing is that in order for her to make the decision, she's still on the fence. We have been able to explain to our client the evidence that has come in up to a certain point, and we have not been able to go over everything with her. So what have you been doing since Friday when the state rested their case in chief? Because this is happening now on Wednesday. So you had Saturday, Sunday, Monday. You got out early on Tuesday.
I'm confused.
We have not been able to go over everything with her. And the court.
Mr. Zellman, to that point, this trial is no different than any other criminal trial that occurs in the state, where the attorneys and the defendant observe the evidence of the state
vis-a-vis a trial
and then have to make a decision. You have been able to consult with your client. I believe you said you went and saw her on Saturday. You had it yesterday. The issue of testifying has not come up. Is that what you're trying to say?
Mr. Zellman, no, Your Honor. That's not what I'm saying. What I am saying is that when we started off representing Mrs. Adelson, There were a plethora of issues that she felt she had to explain to the jury. She has now told us for the first time during the lunch break that there are only a couple of questions in her mind, meaning whether or not she exercises her constitutional right to testify or to not testify.
Lunch break today? She didn't know on Friday? Again, when the state rested their case in chief?
We are not asking for a lengthy period of time. We originally said that our defense case was going to take 4 to 6 days. We're now halfway through the second day, and all we're asking for is for that to get through the additional witnesses that are today. Give us the opportunity, give her that additional time so that she can make that decision, so that we are not put in the position where we're looking at potential ineffective assistance of counsel issues because she is the court. Although you have prepared her. We have, but the decision, it has obviously serious consequences, whether she exercises her right, exposes herself to cross-examination, or whether she is satisfied with the advice that we are giving her concerning her right to testify. So I'm calling BS on all of this. Like, why would that be ineffective assistance of counsel? What has happened if we're on the, what is he saying, the second day of it? Because even though you said your case was 4 to 6 days, there has to be some activity. You can't say, well, we're only through the second day. We're not going to have any more witnesses. We're going to spend the rest of the time sitting with her to go over evidence and help her decide. Like, no. And the jury is just sitting around twiddling their thumbs, or he's telling them to stay home. Like, it's not fair to the jury. So it's moot how many days you ask for. It's how many days are you actually going to have testimony. Couldn't have said our case is 4 to 6 days and 2 of them we're going to just be talking to the client. Like, nobody agreed to that. Okay.
Whether it's this afternoon or tomorrow morning, the situation remains the same. She must choose concerning whether she will testify or not.
Mr. Zellman, I understand that, Your Honor. The court.
Does the state wish to be heard?
Ms. Kappelman. My concern, Judge, is that we've told this jury that the case is going to conclude Friday, right?
3 weeks.
Ms. Fulford, you said the 8th. The court.
Possibly the 8th, Miss Wolford. Don't interject. This is the state's opportunity.
Miss Fulford, I apologize. Now, she should know better as a former judge, girl. Shh, Ms. Kappelman. Yeah, I don't really want to give it to them on Friday night. I don't see what the purpose of another delay is. We've had lots of delays. Sleeping pills. I do appreciate that it's a very difficult decision, but it has to be made, and I don't think it's going to get any easier tomorrow morning than it is this afternoon. So I would ask to proceed and use all the time that we have reserved with the jury as wisely as we can. The court.
How long do you think the examination of the witnesses are going to take this afternoon?
Mr. Zellman, the 2 witnesses this afternoon, Ms. Newhouse, I think direct and cross 15, 20 minutes are plenty to authenticate and exhibit through her, but not, and have it introduced, but not publish it. And then Ms. Descalzo, direct and cross, I don't see it going more than 30 minutes, Your Honor. The court.
This is starting to sound like an issue as it relates to lack of preparation. You have discussed with your client what her testimony would be?
Mr. Zellman, if she testifies, yes, Your Honor. The court.
You have prepared her for this direct and cross-examination?
Mr. Zellman, as best as we can. The court.
How many times, if you can estimate, have you discussed whether she will testify in this trial?
Mr. Zellman, I'm gonna have to refer to Miss Fulford about that. Miss Fulford. I mean, whether she would testify, just that simple subject, has come up lots of times. But actually preparing her and going through the evidence that's been admitted, we're trying to... The court.
This is not about...
Miss Fulford, do that now. The court.
Going through each piece of evidence.
Miss Fulford, I'm not talking the court.
This is whether she's prepared to testify.
Overall. Miss Fulford, well, she has indicated she is not, because she hasn't had an opportunity to discuss the evidence with us, what has come in and what needs to be addressed. She wasn't taking notes. What have you guys been talking about when you're meeting? Just that she has the right to testify or she has the right to remain silent. I'm with the judge. This is given not prepared. The court.
Miss Fulford, how is this case different from any other Florida case where the defendant must make a decision at the conclusion of the state's evidence? One-day trials happen routinely.
Ms. Fulford, right. I understand that, Judge. But this is not a one-day trial. The state, the court.
No, it has...
Ms. Fulford, the state used the court.
Hold on. Don't speak over me. There have been multiple opportunities for you to discuss with your client the substance of her testimony, what she would testify to, and we are at the point where it's time to make a decision. This does not sound like good cause for any further delay.
The defendant. May I say something, Your Honor? The court.
Speak to your attorneys.
Mr. Zellman, the question that Mrs. Adelson had, the statement is, she's asking for the remainder of the afternoon after the other witnesses testify, and she will make a decision at that point. Baby, and people in hell want ice water. No, ma'am. No, ma'am. No, ma'am. The court.
Once the witnesses finish with their testimony, at that time, we will revisit this issue. Concerning whether the direct will start this afternoon is a separate matter from whether she is planning to testify. I need a decision concerning whether she plans to testify at the conclusion of the other defense witnesses.
Mr. Zellman, yes, sir. The court.
Please return to your table.
Sidebar concluded. The court.
This brings us back to where we were concerning whether the defendant is going to testify in this matter. If there are no other witnesses for the defense, it is time for the decision to be made.
Mr. Zellman, I can tell the court that co-counsel and my client are deep in conversation concerning this. The court.
I am capable of seeing that, Mr. Zellman. No narration is needed. Ms. Kappelman, once the defense rests, is the state intending to place or put on any rebuttal case?
Ms. Kappelman, I think not if they rest without calling any further witnesses. That could change if Mrs. Adelson decides to testify.
Very well. At this point, I do need a decision. Mrs. Adelson, please rise. You have been placed under oath earlier this afternoon. Ms. Adelson, I will advise you concerning your rights. Do you understand that you have the right to remain silent?
And this part I'm not going to read because this was, we watched this. So, what are your thoughts on that? We're going to go back. Let me just make myself larger because I know it bothers some of you guys, the scroll. So I just want to go back up to the top to talk about a couple of these things. We've got 7 minutes before we're at an hour, so I think we're in good shape. I'm not going to go, I should have showed you guys that, over the juror thing, other than to say the court confirmed that that video was not deleted. The court confirmed that she never stated what trial, this is juror number 7, the 4-person, she never stated what trial she was assigned to. Maybe I'm going to blame it on the age, like between Fulford and Zellman. Maybe they just didn't know how to use TikTok and they misspoke when they said it had been deleted because they thought it had been deleted. I don't know what was going on with that. But I will say, I don't trust them, especially now after reading the judge's order in response to their motion, because clearly they embellished what happened, and that's why the judge had to come with the receipts, but that's a whole other thing. So basically he's saying they're not going to be able to interview the jurors. The motion must set forth allegations that are not merely speculative, conclusory, or concern matters that inhere in the verdict itself. Consequently, juror interviews are not permissible unless the moving party has made sworn allegations that, if true, would require the court to order a new trial because the alleged error was so fundamental and prejudicial as to vitiate the entire proceeding. So nobody's made a sworn. Moving party is the defendant. They made no sworn allegations. Defendant's allegations do not establish a prima facie case of jury misconduct, but instead encourage the court to engage in a procedure disapproved of by the Florida Supreme Court in Smith v. State. So, yeah. And if that is a sworn thing where they said that it's not a tweet, what is it called? The post have been deleted and they lied. But again, I'm going to give them the benefit of the doubt. So there is an exhibit in the back, but basically this is a capture of what she posted. When I told God I needed a break, and he makes it so I'm selected to serve on a jury for a 2-week trial, won't he do it? Smiley face. Along with the caption that reads, no work, no kids for most of the day. You know what? Heaven, yeah. Which I guess is in lieu of hell, yeah. And then, that was it. Jury was instructed not to communicate with anyone, including your fellow jurors, about this case. No communication includes. So she didn't communicate with anyone about that case in particular, right? She just said, I got picked for a jury. Okay, so motion for new trial and renewed motion for judgment of acquittal. Court concludes the greater amount of credible evidence supports the convictions. This is when they were like, oh, there wasn't enough evidence for the jury to come to that conclusion. Court relies on its previous rulings. What I tell you before? All direct and circumstantial evidence admitted, the evidence demonstrating defendant's consciousness of guilt and its own credibility determination of the witnesses. He was watching. I was right here. What did I determine was credible or not? Stated succinctly, there is evidence in the record demonstrating overt actions by the defendant in furtherance of the murder for hire scheme. See Williams v. State. Members of a conspiracy may have more than one objective. Trial evidence demonstrates defendant's objective for the crimes being completed as separate and distinct from her son, the middle woman, and the triggerman. However, their combined acts resulted in the crimes committed and death of the victim. Because the objective of certain co-conspirators here was obtaining money through criminal acts, the death of the victim did not terminate the conspiracy until the co-conspirators received their payments, right? So the death alone helped Donna receive her objective, but it did not help Catherine, Sigfredo, or Luis because they were in it for the money. So their objective is not completed until they receive that money, which was that evening and then subsequent days. So it was ongoing, where the defense was trying to argue, well, she didn't know about all this until after. The judge is saying there was evidence to support that she did. And even though her objective was just the death, the money hadn't passed hands, so the conspiracy was still ongoing. And even the payments and whatever, because she wrote Katie checks. The trial evidence established defendant's connection to those payments. Defendant's case is distinguishable from Williams. So that was the Denise Williams case where they ended up removing that first degree murder part, or her being a principal in that part. The court also denies the renewed motion for judgment of acquittal, relying on its denial of defendant's initial motion for judgment of acquittal. Same song, different day, ain't nothing changed. Okay. So, decision of any matter of law which arose during the trial. Florida courts have generally allowed the adverse party to delay introducing the other part of the statement until cross-examination. So this is regarding the planners. They argued the rule of completeness, and basically the judge is saying it's a calendar. Like, it doesn't have to be, it's complete. A day by itself is complete. A month by itself is complete. It doesn't have to be the entire year, just by virtue of it being a calendar. Defendant's request was too late because it came after cross-examination of the relevant witnesses. So the court ruled it wasn't timely when they asked for it. And this is the one where they wanted to talk about the items that she had tried to sell previously, where the state had presented evidence that she was trying to sell them right before she left for Vietnam. And they were like, oh, it was 2 years ago. She also had it sold. But because Donna chose not to testify, they were in a bit of a pickle as to how to get this in. And this leads me to believe like she truly hadn't made up her mind. It wasn't a bunch of shenanigans. Because, I mean, what the judge is saying is they could delay introducing the other part of the statement until cross. So I think they introduced it either through Isom or Newsom. I can't remember which detective or which witness. And they could have delayed it, which is what they're arguing. So they had the two arguments. One, the rule of completeness. Two, they could delay the introduction. Judge is saying you had until cross-examination. Like the state had already rested their case in chief and then you brought it up. Because they knew at that point, oh shit, we didn't get this in and now we don't have a witness to get it in to lay the foundation. So basically the judge is like, you're a day late and $1 short. Defendant's request was too late because it came after cross-examination of the relevant witnesses. And I think because they thought Donna was going to testify. Then this comes in. They were not one part of a whole. They were specific dates in the calendars referencing specific events, and those relevant entries were admitted in their entirety. So the rule of completeness is not applicable because the specific dates were complete in and of themselves. Interpreting the rule of completeness to allow for every other entry in the calendars would require the contemporaneous admission of any written or recorded statement that might cast light on an admitted statement. Using the language of Section 90, fairness does not require turning a trial into a voyage on a sea of hearsay. Accordingly, the defendant's invocation of the rule of completeness was properly denied. Moreover, the court permitted defendant to use the entire set of calendar entries as a demonstrative exhibit during her closing, and defendant argued the state did not want the jury to see them. In addition, the 23 calendar entries defendant sought to admit would not rebut arguments that she was fleeing to avoid prosecution when compared to the vast amount of contrary evidence that existed beyond the planner, such as inter alia defendants' text messages, WhatsApp messages, Google searches for non-extradition. So we said this when we talked about it, right? Like that one thing, considering the totality of all of the evidence, wasn't going to make or break the decision. Had they gotten that in, would the jury, like, that wasn't enough to override the urgent visa, the voice recordings, the WhatsApp. It's still like, girl, you looking kind of sus. Where you going? What you doing? For other cause. The court does not find the arguments presented in this claim warrant a new trial. Specifically addressing defendant's decision not to testify, the court relies on the trial record, so we just went through all those receipts. But he was like, nope, gave you additional time above and beyond what you are claiming in your motion, so I've had to attach some receipts because I am not to be played with. And he signed that on the 25th of September. Okay, really quick. Here's what her TikTok looked like when I told God I needed a break, and he makes it so I'm selected to serve on a jury for a 2-week trial. No work, no kids for most of the day. You know what? Heaven, yeah. Won't he do it? And then she has the song Look at God by Corinne Hawthorne. So, yeah, she never said anything about the case. So, or being affiliated with the case. So, they were reaching. It was a stretch. I love that Judge Everett came with all the receipts, though. Let me know what your thoughts are on all of that. Yeah. Thanks for hanging out with me. We're in the home stretch. I wasn't sure if the state was going to respond first, but Judge Everett made quick work of it. He was like, oh, I got this. Hell no. And here's the receipts. Let me know your thoughts and what else you think Donna has up her sleeve. Will we see anything else before appellate team takes over? Well, probably not, because we still have, we have the October hearing, which is not her sentencing. I keep hearing some people reporting that it's her sentencing. It's a conference. Sentencing will either be later in October or beyond, but that's like a check-in for them. So we'll see what kind of foolishness and chicanery Team Adelson comes up between now and then whatever else is going on. I have Donna's call records, only the logs. I don't have the actual telephone calls. And then I've requested the body cam footage of the day she was convicted of her transport, and so I'll have that coming for you. But look out for the phone calls, because I want to see if, and I have the data, but I haven't gone through like matching up all the calls. I want to see if she's talked to Annie Cunningham since the verdict, or day of the verdict, because I'm just curious as to, have her friends dropped her? Will they be dropping her? Were they like, girl, why are you in that acrylic sweater? You don't go here, or we don't go here. So stay tuned. As Miss Kappelman would say, I've got more for you guys. I'll talk to you later. Toodles. See you in the comments.